My name is Beth Clower. I'm the instruction librarian and the business liaison at the Glen Ellen Public Library. I am not going to talk at all unless I pop in to ask a question. If any of you have questions, please do type them into the chat box. Please try not to use the Q&A. It's harder for us to keep our eye on the Q&A than it is in the chat. So for any and all questions, please write them into the chat box. I will keep my eye on that, and I'll pop in and ask Shirley the question when the time seems appropriate. I would like to introduce Shirley Gallant. Shirley is with Piercey and Associates, which you can see here on her first slide. And without any further ado, Shirley, if you don't mind, I'm going to mute myself and let you take it away.
Thank you, Beth, very much. Good evening, everyone. Thank you so much for joining me. I'm here tonight to talk to you. I'm going to give you an overview of estate plans in general, but the key documents that I'm going to go into a little depth on are the powers of attorney. In the state of Illinois, we have power of attorney for healthcare and power of attorney for finance. And more recently, in the last few years, we've come to realize that we need a third power of attorney, and that is the power of attorney for mental health. So we're going to talk about all of those. First of all, oh, why did that change? Hang on. Oh, there we go. So as Beth introduced me, I am Shirley Gallant. I am an attorney that specializes, or I shouldn't say specializes because the state of Illinois doesn't recognize specializations, but I focus my practice on estate planning with an emphasis on special needs and elder law to ensure that the folks that are most in need and have the help that they need to ensure that they are setting up their estates that in a manner that would allow them to also receive benefits if they happen to be getting them. But that's much more in depth than what we're going to get. Law is a second career for me. I started out after college in corporate America, worked in corporate America forever in procurement. And I always ended up being the liaison between the procurement department and the legal department, and was always told I should be a lawyer by the legal department. And I thought, well, let me see if I can do that. Went to law school while working full-time and being a mother of four, and realized in the first year that if I continued down the road of looking at contracts for the rest of my life in the way that an attorney has to look at them, that I probably wasn't going to be a very happy human being. I complained about that to one of my professors, who actually was the director of the elder law clinic at my law school. And she convinced me to go to work for her for my last year of law school and in the elder law clinic. And I actually fell in love with this area of law, the estate planning. I was appointed in Michigan, where I went to law school, by the federal judges to be GAL guardian ad litem, and realized that this is the area that I wanted to be in. So as soon as I was able, I left corporate America and struck out on my own, and here I am. I've been with Piercey and Associates for almost 2 years now. I moved to Piercey and Associates because of their focus on caring for the individual, and that being the utmost importance to us. So that's why I'm here tonight. In being able to work for someone who cares about their clients, I'm able to go out and teach and to do these seminars, and they encourage that and support it. And so this is what I do on a pretty regular basis. I also teach twice a year other attorneys this area of law. Okay, so what we're going to go over is we're going to discuss why you need an estate plan and what the basic estate plan should look like, what an estate plan documents are, as I mentioned briefly in the introduction, powers of attorney. There's also the last will and testament, and trust, and other specialty documents, which we will just briefly touch on, and I probably would be more than happy to do another seminar at a later date if there seems to be enough interest. But then we're going to get into the meat of this, which is the importance of powers of attorney. you're going to determine, you're going to learn how you determine what a POA is when it's needed, how you can select a agent to represent you, and what you need to do to accomplish all of that. Okay, as Beth said, should you have questions, please type them into the chat bar and Beth will stop me and we'll answer the questions as we go along, okay? I do want this to be interactive. I do want you to ask questions as we go because I want to make sure that we have time that everybody gets their questions answered. I will tell you this, I cannot answer a specific legal question for you. I can answer a general legal question for you. So if you have a situation, please present the question as, so if someone had an issue with this, not that I have an issue with this, I can't give you legal advice. Okay. Okay, why do you need an estate plan? Well, the answer to that is that it's life. Every single day, and I think within the last year, everyone has seen that within a blink of an eye that our entire lives can change. And when something happens, if you don't have an estate plan in place that covers you for all possible scenarios or for as many as you can possibly think about, you could put yourself and your family in jeopardy. You could end up where you would have to be oversought by the judicial system, in that somebody could have to go out and get a guardianship over you. If you become a ward and there is a court that has adjudicated that you need to have a guardian named for you, that guardian is going to have to report to that court every single year. There are two reports that they would have to provide to the court. First one would be a report on ward, which is a healthcare type of report. And that report, as I said, is due annually, along with a report, a financial report of an accounting. Once somebody has been adjudicated as ward of the state, and a guardian is appointed, your assets are all looked at, and the court oversees a budget for you, oversees how that budget can be spent. They will restrict how things can be spent in regards to your long-term care, so that the money will last as long as it possibly can. But again, you are under the court's jurisdiction. So like I said, why do you need an estate plan? Because life happens. And when life happens, you want to be prepared so that you and your family and loved ones and the ones that you trust and you've had very hard, long conversations with can act for you on your behalf. So the basic estate planning documents are the powers of attorney, healthcare. Now, the healthcare power of attorney also includes HIPAA documents under the Affordable Care Act, where your agent or your agent for healthcare, or anybody else, as far as that's concerned, that you stipulate in your HIPAA release form, is able to have access to your healthcare information, and not only the health part of it, the medical part of it, but also the financial part of it, so that they could help get financing, help pay for things, and so forth. The next power of attorney is finance. In the state of Illinois, it's not referred to as a power of attorney for finance. It's referred to as a power of attorney for property. So in that, the latest revision of the power of attorney for property law in the state of Illinois requires that the agent that you select to be your agent has to sign an acceptance of office. And that acceptance of office is a one-page document, generally, depending on the size font that someone uses to print it. But one-page document that outlines the fiduciary responsibility of your agent for your finances, and also the legal liability that they're taking on. And when they sign it, they're signing their admission to the state that they're going to handle your affairs appropriately and legally. And the last power of attorney that I mentioned briefly just a few minutes ago is the power of attorney for mental health. This is one that within the last 5 years, I have had to deal with more and more. One of the things that I don't know if I mentioned it or not, I sometimes do, sometimes don't, but I'm appointed by the Cook County Probate Court quite often as guardian ad litem. A guardian ad litem is a person who is appointed by the court to go out and act as the eyes and the ears of the court and investigate the situation. Usually a guardianship, sometimes it has to do with child custody and things like that, but generally guardianship in the area that I work in. And you have to investigate the party that's asking to be guardian. You have to investigate the party that the guardian or the petitioner is asking be adjudicated a disabled adult. You have to investigate whether they need a guardian and for what reason. You have to speak to the doctor. And within the last 5 years, I have been exposed more and more to incidences where adults have mental health issues. And if because mental health is such a different beast, so to speak, the probate court will not appoint a guardian if someone is suffering from a mental health issue without having to, in addition, go to probate. You will have to go to mental health court and get adjudicated that the person has a mental health issue that needs to be addressed, and then go back to probate and get guardianship. It's quite an extensive situation and quite costly. So if there is a history, if there is something that would lead you to believe that someone might have mental health issues down the road, say a diagnosis or with a prognosis of memory issues or whatever, putting a mental health directive or power of attorney in place will help your family save money in the long run and ensure that you receive the care that you need. The next basic estate planning documents that we're going to talk about are briefly as wills. There are two types of wills: a standalone will, which is just the legal document that becomes a legal document the day you die. Prior to that, it's just a piece of paper with words on it. But the standalone will means that there is no trust in the estate plan, and that everything that you want to happen with your estate is set up to happen through the will. Now, the thing about that is, if you that still has to go through probate. So if you have over $100,000 in your estate, or if you own real estate. In the state of Illinois, if either of those two circumstances meet your particular circumstance, then your family will have to go through probate. Now, probate is something that at minimum takes 14 months to process. And I have seen probates last up as long as 7 years. That's the longest one I've had. And everything that happens within your estate becomes public knowledge. So when you go through probate, anyone who chooses under the Freedom of Information Act to inquire as to what's happening with your estate can get access to your entire probate file. They can go to the 12th floor in Cook County at the Daily Center and ask for the file, look up the case number, ask for the file, and copy every piece of it if they wanted to out of it, and that's perfectly legal. Now, a pour-over will is the central document that is utilized when you have a trust. And what that document does is name the person that you want to be your executor and then to be your trustee to handle your estate through your trust, which does then not have to go through probate, provided that the trust has been funded properly. A pour over will is just that. There's a clause within the pour over will that states specifically that everything I own that has not been titled to the trust should now pour over into the trust. That's great. And as far as drafting is concerned, where you run into problems with it is that if you do not have a good estate planning attorney that explains to you that you must fund your trust with anything that has to be titled, i.e. Real estate, vehicles, motorhomes, boats, anything like that. If you don't transfer the title to those prior to dying, the pour over will won't let it happen independently. And if there's real estate involved, you would still have to open a probate. So you need to make sure that when you are looking for an estate planning firm to help you with your estate, that you choose one who not only will assist you in funding your trust, but will also give you very good direction on how to do so and to do it immediately upon creation of your trust. The last basic estate planning documents that we're going to talk about are trusts. There are numerous types of trust. The most common are revocable and irrevocable. Revocable means that at any time, anything and everything that has to do with it can be changed. Irrevocable means that once it's put in place, while there can be amendments and things done to it, it can't be liquidated until everything that has been listed in the trust that needs to transpire transpires. Then there's special needs trusts. Now, special needs trusts are something that are near and dear to my heart. Special needs trusts are also trusts that we put into our trust as testamentary trusts, meaning that they would come into effect when someone died that was the grantor of the trust, should the beneficiary of a piece of the initial trust need special needs or have an issue where they were receiving SSI or any other kind of benefit, and you wouldn't want to jeopardize that, then their inheritance through the trust would be put into a special needs trust and handled that way so that they didn't lose that benefit or that they didn't qualify for that benefit. A couple of other types of specialty trusts are paid on death. POD, paid on death. That generally has to do with financial accounts, bank accounts, investment accounts, and those sorts of things. Also, there's the TODI, and that trust is where is for real estate. It's very complicated, so I'm not going to get into it much more than that. And then there's the disability trust, and also there is a prepaid burial trust. Now, one of the other things that if you're in a situation where your parents or even you are thinking that down the road you might need to apply for Medicaid, setting up a pre-burial trust is something that's very important. However, again, you should ask an estate planning attorney because there are very specific elements that have to be met within a pre-burial trust for it to be Medicaid compliant. Okay, so I'm talking a lot and nobody's saying anything. Anybody got anything to say yet? Okay, so let's talk about the meat of what we came here to talk about today. Let's talk about the powers of attorney and the importance of them. So, we've all experienced over the past year the global pandemic, and we're still in the middle of it. I mean, I don't believe that we're anywhere near finished with it, but at least I think that we're topping the hill in regards to the pandemic. But this situation in the world has caused a lot of people to realize that they don't have their estate in order and that they don't have everything set up. Powers of attorney, in my opinion, are the most important document that an individual can have as a legal adult. And I say that because a power of attorney is only effective as long as you're alive. And as long as you're alive, you want someone who you have had very specific and in-depth conversations with and trust to be your agent to act for you in the event that you can't act for yourself. Okay, so having the right person and putting those documents and making sure that they have the right clauses are, in my opinion, the most important estate planning documents that you can have. I don't care if you're 18 years old or if you're 118 years old. As an adult, if you were to become injured and not be able to talk for yourself, if you don't have a power of attorney in place, then the state mandates how things are handled. I can't tell you how many times people say, oh, well, I'm married, so my husband or my wife can handle it. To an extent, that's true. However, if you were in a situation, even with a spouse, where you were in a vegetative state and the plug had to be pulled, if there was one family member or one person who objected in front of the medical personnel, chances are that plug's not going to get pulled. Okay. So that in itself is a reason. I have a very dear friend who is in a second marriage situation. She has 3 adult daughters and her second husband, and she under no circumstances ever wanted to be intubated for anything, no matter what. Even if it cost her her life, she did not care. She did not want to be intubated. And she had talked with her daughters and her husband, and they all said, sorry, we're not doing that. If you need to be intubated, we're going to have you intubated. And she came to me and she said, I really feel strongly about this and I can't do it. I would like you to be my power of attorney because I know that you're strong enough to stand up to everybody and to get this done. And to this day, I'm her power of attorney. She moved out of state and lives down in Florida now, but I'm still her power of attorney. And she's had a couple of heart issues and I've actually been called, not because of intubation, but because I'm her power of attorney for healthcare. But my point is that if you don't have a power of attorney in place, and you don't have the important conversations with the persons that are you're naming as your agent in regards to your health and what your wishes are, then you really are at the mercy of the courts moving forward and determining whether what your family wants to do or what they think you want to do is going to get done. Other reasons include accidents. Any one of us can walk out of our door on any given day, step off the curb and get hit by a bus. And unfortunately, in the world that we live in today, any one of us can go to the grocery store and not come home or get sent to the hospital in a condition. So with the world situation, there is an upswing on drinking and alcohol abuse. And experimentation with drugs. So with that, medical issues come up that would not generally be thought of and should be thought of. And also then with everything else going on in the world, we're facing more mental health issues, depression, suicide, paranoid schizophrenia. All of these things are reasons to ensure that you have your powers of attorney in place. I even had a call today from a man and his wife. He has just been diagnosed with a brain issue that will in the next 6 years render him unable to make decisions for himself. And when we were talking about putting their estate plan together, I mentioned the mental health issue, and they both decided that it was an extremely important power of attorney that they wanted to include in their plan, specifically because of his issue. And if you think about it, I just think it's a smart thing to do. What the mental health power of attorney allows for is it allows your agent doesn't have full say. Your agent has to work hand in hand with your treating medical doctor, and together they make the decision. Whereas if you don't have a mental health directive in place, the doctor will make certain decisions, but then anything past a certain limitation would have to go in front of the court, in the mental health court, to get permission and court order to do so. So it's another power of attorney that everyone should consider. Okay. Okay. So we're going to go into a little bit into depth here. What happens when you cannot make medical decisions for yourself? So without a power of attorney or for healthcare or a HIPAA release form, your medical doctors, facilities, hospitals, whatever, treatment centers, by law, they are not supposed to speak to anyone about your medical issues, your medical treatment, your medical prognosis, or what treatment plan they're recommending without your written consent. If you're not able to give your written consent, then their hands are tied. And because of that, something could happen where you were placed on life support for an extended amount of time, like a Terry Schiavo. Your medical costs and any insurance that you have could be depleted very, very quickly when you're in that type of situation. With the power of attorney, your designated agent has the right to make decisions on your behalf when you're not able. They're able to determine what treatment and care you get. They're able to get second opinions for you, third opinions for you, do whatever. They are your advocate. They are your voice. They are the ones who are making the world of the medical world aware of what you have decided and what you have shared with them prior to coming into crisis. And this includes, of course, end-of-life decisions. And with the HIPAA, as I said before, your loved ones, they're able to access your medical information, your treatment, your medical bills, so that they can ensure that everything is taken care of. They can then, by doing so, protect your assets, your overall assets, moving forward. I apologize. I have to, excuse me 1 second. Oh, sorry. Okay. Real life, right? Okay, now we're going to talk about powers of attorney for finance, or as in Illinois, it is referred to as power of attorney for property. Without a power of attorney for property, your financial accounts, if something were to happen to you and you weren't able to speak for yourself, your financial accounts could be frozen to protect you from fraud or somebody taking advantage of you because you weren't able to take advantage. I mean, you weren't able to speak for yourself or to handle your affairs yourself. This could also result in going through probate and getting a guardianship put in place. And guardianships are most often put in place because of finances, not because of healthcare, but because of finances and the chance of someone being taken advantage of and someone taking off with their money. So if you don't have a power of attorney for finance, and you're in a position where you can't speak for yourself, your bank generally will not speak to anyone and let them take your money without some sort of court order. So you're going to end up in probate to accomplish that, okay? So again, I had spoken earlier about the mental health power of attorney and going to guardianship and all that, and the reporting that would be required. this is the same case. You would be then a ward of the state, and your full assets in your life, your financial life, would be laid out in the court arena for anyone to take a look at. And the judge would have to approve an inventory and an accounting for you every year, and also look at a budget to ensure that your money was not being wasted on things that it shouldn't be wasted on, but was being used for your care. Again, while going through guardianship sometimes is unavoidable, getting there and staying there can be quite costly. So if you were to put a power of attorney for property and healthcare in place, you can prevent going through the probate court and getting a guardianship altogether. One of the things that I wanted to say about powers of attorney is that well, let's talk about mental health. Okay, we have talked a little bit. Let's go into this. Okay, so without a mental health power of attorney, your family's hands are tied. If you are having a mental health issue, you can be put into a mental health facility for a period of 72 hours, but after that, they have to let you out, or the doctor has to commit you for a reason. With a mental health directive in place, your agent that you've named is able to work hand in hand with the doctor, without a court, without two courts, without a judge, without lawyers, and determine what care that you need. Your agent can also have you committed for as long as 14 days for observation and treatment. The studies say that a person who's having a mental health episode generally needs 14 to 21 days to settle, for their chemicals and everything to come back once they're being treated. For whatever reason, the legislature decided that a mental health directive would only allow you to be committed for 14 days. We find that this is very helpful in that at least at the 14 days, I have not experienced anyone who has not gotten to the point where they are able to have their treatment to a point where they're working with the family again, rather than working against themselves and everyone else who's trying to care for them. So at least the 14 days generally, in my opinion and in my experience, has been helpful to the point of actually making sure that the individuals are getting the care and the treatment that they need. Okay. And as I said before, your agent will have to work with the healthcare professional, can't work independently, can't direct independently. Whatever the agent is professing to be done, a mental health professional would have to agree, treating professional would have to agree, and they would act in concert. Okay, so the next area is to go into how you select an agent, but I want to go into a little bit, because I don't remember if I put that in this presentation or not, but I want to go into what you do with each of your powers of attorney, okay? So this, I'm just going to, okay. So a power of attorney for healthcare. Once you've executed a power of attorney for healthcare, all originals should be kept of whatever, but all originals should be kept in a fireproof, waterproof location. The originals should also, you should also convey to the agents where the originals are for healthcare, property, and mental health. But then each of them, copies should be given to various professionals. Healthcare, a copy of your power of attorney should be given to your primary care physician. If you have a local hospital that you go to, you should give them a copy of your power of attorney for healthcare. In addition, it is good practice to keep a copy of your power of attorney for healthcare in the glove box of your vehicle. I'm Irish, and I come from a big Irish family, and have many firemen and nurses in my family. And one of the things that I learned very long time ago from one of my cousins who's a paramedic is that one of the first things they do when they get to an accident, someone that is there from the fire department will check the glove box to see if there's a power of attorney in the glove box, so they know who to contact to get the agent ready to act should it needed to happen because of the accident. So I keep a power of attorney in my glove box. The HIPAA release, you should just make sure that your agents have that, and that your primary care physician has that. Now, your power of attorney for property or finance, you must give a copy to your local bank. Anywhere that you have a banking account, if you have, several banks, you give them all a copy of your power of attorney. And you do it when you execute it, even if the power of attorney isn't in effect yet. One of the things that you need to decide when creating your powers of attorney is whether you want your power of attorney to be effective upon signature, or whether you want your power of attorney to be effective because of an action, meaning that a physician says that you can, that you need assistance, or that a court of law, I don't generally recommend that because that means you're in probate. But many people will opt for, they don't want the power of attorney specifically for finance to be in effect until they can no longer act for themselves and their physician says that they can't. But because of that, when you're in crisis, if you have not given the power of attorney for finance to your bank or your financial representative, and they've not presented it to their legal team prior to, when you're in crisis, when you have what's called a springing, meaning that it doesn't go into effect until this condition happens, when you then have the emergency and your agent goes and says, I've got to do this, I got to get money to take care of him or her and move her here and do this, you have, whoa, wait, the legal department has to review this power of attorney. And that literally has taken 3 to 10 days in my experience, depending on the financial facility. So it's very, very important that when you execute your powers of attorney, that to complete the circle, that you make sure that you give the bank and any financial agent or financial institution that you're doing business with, Fidelity or whomever, you give them a copy of your power of attorney. By you doing it when you have capacity, this is saying to them, not only you personally are giving it to them, not the agent saying, oh, I'm in charge of all the money now, but you personally are giving it to them. By you doing this and you doing it before there's a need, every single instance in my 15 years of experience of this, every single instance, it has, when an emergency situation comes up, when the principal, you as the principal, has given their power of attorney to their financial institution, it has run very smoothly and there's been no hiccups. I think the longest that we had to wait was about 4 hours one afternoon on one. So the importance of giving that document to your financial folks is very, very important. Now, your mental health directive, I would give that to your primary care physician and your primary care physician only. But those are what you should do with those documents once you get them. You should also give your agent a copy, okay? But as I said, your agent should also know how to get their hands on your original, just in case someone is requiring that they see the original and make a copy of the original. Even though you're giving them a copy of the original, they sometimes will cause issues, okay? So we're going to talk about selecting an agent and the importance of this. You have to consider the weight and magnitude of the role. And you have to be sure that you are selecting someone who will follow your wishes, and not necessarily, even if they not necessarily agree with you. Like me in the case of my friend, I don't necessarily agree that if you just need to be intubated for a period of time that you should not do it. But that's her wishes. That's what she wants. That's a fear that she has. So you need to consider the personality of the individual that you're going to select as your agent, and whether you think that they would be able to have the strength to pull off what it is that you are asking them to do for you. You're asking them to stand up for you when you can't, and to be your advocate, and to fight whomever they have to fight to make sure that your wishes are followed. Okay. In regards to the finance, you have to select someone who understands the legal obligation that they're making, and that you feel and trust, that you could trust with your financial matters, that there's no way that you believe that this person would ever, under any circumstances, do anything to take advantage or to steal from you. So these are things that you've got to consider when you're looking at selecting an agent. When you create your documents, your estate planning documents, you need to understand also that having just one individual in place as your agent or as your trustee, successor trustee, because generally you're your trustee until you can't do it anymore, then, but successor trustee, there should always be someone behind them. So there should be a successor to every person that you select to be part of your estate plan. And and as I've said earlier, these are individuals that you should have very informed, very in-depth conversations with about very hard issues. And so you need to make sure that you have two people in place. Now, I say that, and I can't tell you the number of people who say to me, oh, I don't know, I only have one person I can depend on. Okay, let's get them drafted and get the one person in there so that there's someone. Let's not leave you there out there in the cold with no one. Let's get the document drafted with the one. And every single client that I have, I say this to them: let's get the one in, and then as we're moving down the road, when you find number two, I'll redo your powers of attorney for free. And I do, because as I mentioned when we started this webinar tonight, this is, in my opinion, the most important documents that you can have. And I work really hard to ensure that every one of my clients are protected no matter what. So I will execute powers of attorney with only the single agent named. And then down the road, and I've had clients come back to me 3 years later and say, okay, I'm ready to add a successor. And I'm like, okay, let's do it. And I do it because to me, it's that important. Okay. So anybody have any questions on how to select an agent or anything like that? You guys are awful quiet.
Yeah, I'm not seeing any questions yet. So.
Yeah. Okay, well, let's move on. Okay. Oh, why didn't it go? Okay. Okay, we'll have technical difficulties. What now? Okay, so now you understand the importance of powers of attorney in an estate plan, and specifically, you need to know what you should do now. Well, oh, I don't know how that happened. I apologize. Boy, oh boy. Technology is not my thing, just in case anybody's wondering. You should call an estate planning attorney. Okay, there are thousands of them in the state of Illinois and in the area. Okay, and you should ask for a consultation. And many of them vary. A lot of firms will charge for a consultation. Generally, they shouldn't, in my opinion, charge for consultations, but don't expect to talk to somebody for more than a half an hour for a free consultation. Okay.
Real quick.
Yeah.
Thank you so much. Sorry about that.
No.
we did end up with a couple of questions, actually.
Okay, good.
I'm going to read both questions and then you can tell me if you can answer them both at the same time or not. How often do
Okay.
documents need to be updated? And what is the best way to select an agent, especially if you don't have a family member to go to?
Okay. Okay. So, what was the first one? I already forgot it.
How often should the
Oh,
documents?
okay. Yeah. Okay. So your estate plan as a whole, we say that you should have it checked every 3 to 5 years. When we put an estate, when our firm puts an estate plan together, we have we calendar immediately a checkpoint at 3 years. And all we do is just make a call and check in with you. You don't get charged for it, but we call and check in with you. How are you? How are things going? Has anything changed? Did you buy a new piece of property? Did you get married? Did you have another child? Did, something like that happen? No. Okay. Then we put on the calendar to check with you at 5 years. Okay. We do the 3 and 5 years initially because we have found that quite often when people do take, I don't know why it's always so hard for people to take the step to go in and do their estate plan, but when they do go in and do their estate plan, once they do it, now their mind just opens up. They're like, oh, well, what about this? And what about that? Our firm will make minor adjustments to your estate plan for 6 months for free. And for 1 year, we will answer all of your questions for free having to do with your estate plan. But then at 3 years, we call and we check in with you because, like I said, all too often people all of a sudden, down the road, they're like, oh, well, I gotta think about that for my estate plan. So we have a conversation to say whether, something needs to be done or not. Then we check in with you at 5 years. If everything's copacetic from 3 to 5 years, or 3 years and then 5 years, then we don't check back with you until year 10. Excuse me. So generally speaking, when you first do it, the first 3 to 5 years, you should look at it, talk to your attorney, make sure that everything is still within reason. Now, if you've gone to a good and a good, focused, and truly managed estate planning firm, they will contact you should there be something that transpires in the legislature that changes everything having to do with your estate plan. There was just January 1st, 2020, there was the first Uniform Trust Act change national change in multiple of years that changed a lot of things that had to do with a lot of people's estates. And so we spent most of the entire year last year contacting all our former clients that had trusts that were affected, saying, look, this new law is in place and we need to talk to you, to help you ensure that you're still protected and everything that you want to accomplish with your estate plan is still in place to do so with these new laws. So your law firm should contact you if there's any legal changes that would affect, but generally every 3 to 5 years, you should look at what's gone on in your life, what's changed in your life, and how it might change your estate plan. The next question was, what do you do if you don't have someone in your family? And it's quite funny that as this last year, it has been more prominent than it has ever been in my 15 years of being an attorney, where I have had more individuals who do not have anyone. So as far as powers of attorney for healthcare and finance are concerned, if you truly have no family member and or no friend that you feel that you comfortable enough to have the conversations and to a point, there are companies who are legally bound, and they do it. Of course, they do charge a fee. You might be able to get an attorney to be a power of attorney, one of your attorneys to be a power of attorney for healthcare. You're not going to find an attorney to be power of attorney for finance because the licenses and things, I could not do that. But if you needed someone to be trustee or executor, you will find law firms who have senior partners who will do that, take on that role, and the law firm handles it. But when it comes to powers of attorney, you really need to see if you can find a family member or a friend that you trust, or there are agencies that you can hire that will do it. Does that answer that question, I hope? Okay.
I don't see a response yet, but we're gonna, yes.
Yeah, okay, okay. So, okay, we talked about all of that. There was something else I was going to tell you, and now I've lost it. Okay. Oh, so you what now? You need to find an estate planning law firm. Yes, when you go in to talk to a firm about an estate plan, they are going to try to sell you the whole package. Okay. We do it as well because we understand the importance of it. Okay. But if you truly only need powers of attorney, you can find firms that can and will do it. I would ask that you be very, very sure that any firm that you select and that you decide upon, when you're talking to them about powers of attorney, and specifically about the powers of attorney for finance or property, the state of Illinois' statutory power of attorney enumerates approximately 22 different types of financial transactions that an individual can do for you as your agent. As estate planning attorneys and especially elder law and special need attorney, I have learned over the last 15 years that there are an enormous amount of areas that doesn't cover, even though the last one on the list is all other. If your agent, for whatever reason, had to sell your car to pay for care for you under a statutory simple power of attorney that anybody can print out and execute, if that's all you have, they will never be able to sell your car for you and get the money to take care of you. If you have an estate plan in place that restricts your agent's access to different things, if you don't have additional powers enumerated on your power of attorney for finance, they're never going to be able to adjust your estate plan to make sure that you're cared for, or that you have the resources to be cared for, or the assets. So to give you an idea, the power of attorney for property, when it's the statutory power of attorney for property, when it's printed with 12-point font, is approximately 7 to 9 pages. Okay. The powers of attorney that my firm drafts for property is 17 pages. And the additional 8 to 10 pages has to do with the additional powers that we have determined through our experience are not covered under that all other in the statutory powers of attorney. So when you reach out to a firm to talk about powers of attorney, make sure that they are talking to you about additional powers that need to be added to the power of attorney for property. Okay. Healthcare is pretty straightforward. There's nothing that really needs to be added. There are decisions that you have to make when creating your powers of attorney, the statutory power of attorney, such as you have to make the decision as to whether if you were at the end of life, you wanted them to do absolutely everything, no matter the cost, no matter the likelihood, no matter what, to keep you alive, or whether you would like them to keep you comfortable and pain-free and let nature take its course. That's one thing. And both the power of attorney for healthcare and the power of attorney for property, you have to make the decision whether they are effective immediately or whether they become effective upon a condition. I always recommend to my clients that healthcare power of attorney become effective immediately. And the reason is because, like I said earlier, life happens. You literally can step outside and be in need immediately for your agent to act for you. So if you don't have it become effective upon execution, that agent can't act for you. So immediately in an emergency. So for healthcare, I always recommend to my clients that it be immediate. Finance, that's a personal decision, and that's going to be a decision that you're going to make based on your comfort level individually as a person, and then your comfort level with the agent that you've selected. Okay. I'm trying to think if there's anything else.
Can I ask?
Go ahead. I'm sorry.
It sounded as if in one of the things you're saying about the length of the document, et cetera, that it's not a good idea to go online and just get one of these free power of attorneys that you print off for free and fill it out. What are your thoughts on that?
Well, my thoughts on that are, thank you for taking the initiative to do something. However, you may not be putting yourself in the best possible situation. Okay. Oh, that's what I wanted to say. If you are looking just to have powers of attorney executed, the going rate in the area for doing a set of powers of attorney is between $500 and $750. If you add a mental health directive, it can go up to $1,250. Now, when you go to an estate planning firm, many of them will break it out and charge you individually, but then a lot of them are also putting it in the package. So like for our packages include your powers of attorney, all the ancillary documents, your pour over will, and your trust, and all of the ancillary documents that go with that, and including funding. And it's one price. So you're actually getting your powers of attorney for free. They should not be overly expensive, but to ensure, if you pay $5 for powers of attorney that have not been added to include the additional powers that should be enumerated to protect you all the way, then that firm should not be doing that. To your question, Beth, anything's better than nothing, but sometimes you cost yourself more money than you would if you spent a little bit of money to have it done properly and to cover all bases. Does that answer that question, I hope?
It does. It does.
Okay.
We actually have people come into the library on a regular basis asking us to help them find a free online will or a free online whatever.
Oh gosh, no, I would never, ever, never, ever, 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 ever. I was talking about powers of attorney. Will and trust, never, ever, never, ever, 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 ever. Because you right now, if you go and get a will offline and try to execute it, I guarantee you, your family is ending up in probate court, and it's going to cost them many more thousands than it would have cost you to get your estate plan put together. I would never, ever recommend. Powers of attorney, however, the basic is the basic, and it could help you. It's better than nothing. I still don't recommend it. It's better than nothing, but I would not recommend it. I would say that you would want to go to an estate planning firm and ensure that you get the additional powers so that you're completely covered. So.
All right. Does anybody else have any questions? We are coming up to the end of our time. I don't want to cut anybody off if you have questions. There's been so much information, Shirley. Thank you so much.
You're welcome. And I'm happy to answer any question. Like I said, this is a passion for me. I feel very, very, very strongly. I have 4 children who are all adults now, and you can ask each one of them the moment they became 18 years old, they sat down and they executed their powers of attorney. I feel that strongly about it. Powers of attorney are the most important documents as living human beings that we can have in place.
And you might want to make one kind of sentence. Shirley was very kind before she did a presentation for us, and it was very much about why you should have power of attorney for your adult children who are 21, 22, 23, and you think, oh, they're children, they don't need anything. Shirley, do you want to just very quickly in the last minute to speak to that?
I would love to speak to that. That was one of the catalysts that got me deciding that I needed to create these powers of attorney and try to promote them in regards to these presentations on powers of attorney and promote trying to be able to go out and talk to people. As I mentioned, I've often been, I get appointed guardian ad litem in Cook County. In the last 5 years, I have become guardian ad litem for a total now of 5 young people who are under the age of 25 who have had catastrophic events happen in their life, and they are now either in a vegetative state or completely physically disabled, and because they had no powers of attorney in place, their families are in probate court. And they have been in probate court from the time that the accident happened, and will continue to be in probate court every single year for the rest of that young person's life, to ensure that, because once the court takes jurisdiction over that young person or over any person, once the court takes jurisdiction, until that person is able to prove with medical backing that they can now care for themselves and they no longer need a guardian, the court has to oversee them. The court is obligated to ensure that their finances and their care is properly handled. And you can't get away from it. You can't do anything. I had one of the very first young ladies that I got appointed for. I say this, she literally stepped off a curb when she went away to college for the first time in St. Louis, stepped off a curb, and an 87-year-old man hit her, and she's now in a vegetative state and has been since that occurred. Her family wanted to move to Florida. And what we had to do, the hoops that we had to jump through in order to get everything put into place so that they could move her to Florida, was unbelievable, and the cost was astronomical. And that people, you're young, you're invincible, you don't have to worry about these sort of things. It's not true. As soon as you're an adult, you need to worry about these things, because you can say, oh, my mom and dad are going to take care of it. Legally they can't. They literally can't without court assistance if you don't have powers of attorney in place.
Excellent. Thank you. Did you have a slide that had your contact information on it?
Yeah, I think the questions, and here I am.
All right. So if anybody,
I'm in Oak Brook.
Go ahead.
I was just going to say, I'm in Oak Brook, and there's my number and my email. So feel free to take it down. And if you have additional questions, reach out. I'll be happy to respond. Okay.
And thank you so very, very much. We are out of time. And
thank you for asking me again. You know, I enjoy doing this. I'll do it anytime you ask.
I'm sure we'll have you back at some point in the future, but thank you. And to all of you who came, thank you very, very much.